situation. Mr. Speaker, you'll be glad to know we're 110 seconds within your limit, so I could filibuster, I think, a little bit longer. But no, I don't wish to be too glib on this. Can I just say that I know we're going to come back to this a lot in the future. Can I thank all honourable members and right honourable members for their contributions? I appreciate, and they will appreciate, that for obvious reasons, one or two of the replies will have to go out in writing. But this is something that I think we should greatly be to our credit. The fact that we are a UN penholder on this Yemeni issue is one that is very close to our hearts. We're going to do a lot of work continually on the humanitarian side, and I think some of the most important work that we do across the globe will happen, and many, many lives are going to be saved courtesy of the British taxpayer.
Thank you. Order. Business statement. The Leader of the House and Lord President of the Council, Andrea Leadsom.
Mr. Speaker, to assist the House, I would like to make a short business statement. The first business tomorrow will reflect the decision taken by the House yesterday. At the conclusion of that business, the Government will bring forward the draft European Union Withdrawal Act 2018 Amendment Regulations 2019 for consideration. Thank you.
Valerie Vaz.
Thank you, Mr. Speaker. Can I thank the Leader of the House for the statement, and we welcome the fact that we can approve this statutory instrument that is going to extend the exit day. I just have a couple of questions for the Speaker, Mr. Speaker, for the Leader. Could I ask her when the meaningful vote will be brought back, given the Prime Minister said it would be coming back this week? And can she confirm it is also the Government's understanding, if the meaningful vote is passed, exit days on the 22nd of May, and if there's no meaningful vote, we leave by the 12th of April, and there will be a further extension if we show purpose. But obviously we welcome the fact that this uncertainty of the 29th of March has now, albeit moved, to the 12th of April.
Thank you to the Honourable Lady for her questions. What I can say is, as the Prime Minister has made very clear, the Government does continue to believe the best way to leave the EU is with a deal. And the deal that she has negotiated has taken the best part of 3 years, is extremely complicated, and it remains our view that it represents the best compromise for leaving the European Union whilst keeping a close economic and security partnership. So, as the Prime Minister has said, she will continue to have discussions with colleagues across the House to seek to build support for her deal so that we can, if possible this week, approve the deal and guarantee Brexit. But to the Honourable Lady's specific question, the draft statutory instrument that the Government hopes to bring forward tomorrow will provide for 2 durations that were agreed with the EU27. Exit day, as amended, would be the 22nd of May if the withdrawal agreement is approved before 11 p.m. on the 29th of March. Otherwise, it would be 11 p.m. on the 12th of April.
Thank you. Order. I understand the appetite of colleagues. This is an important business statement by the Leader, but its terms are relatively narrow, and it's not the normal business statement, so it really should focus on tomorrow, which is the subject matter on which the Leader focused. Mr. Peter Bone.
Thank you. Mr. Speaker, could the Leader just clarify? I thought the Act required an exit date, not 2 optional dates. So I'm surprised that the statutory instrument is actually naming 2 dates. I would have thought the right would have been to have the 12th of April and then extend later if need be. And I'm also right in thinking, and I'm sure the Leader would agree, that until those statutory instruments go through both houses of this Parliament, if they do, we will be coming out of the European Union, at least domestically, in 3 days' time.
Leader of the House.
So this is an incredibly important point that my honourable friend has raised, Mr. Speaker. This House voted on March the 14th for a short extension to Article 50. The EU Council's conclusions were turned into a legal decision with which the Prime Minister, the United Kingdom, agreed, and those conclusions came into force last Friday. So the date for our departure from the EU has already changed in international law. The draft statutory instrument provides for both the durations that were agreed with the EU27. As I said to the Honourable Lady opposite, exit day as amended would be the 22nd of May if the withdrawal agreement is approved before 11 p.m. on the 29th of March. Otherwise, it would be 11 p.m. on the 12th of April. But I do want to be very clear that a rejection of the statutory instrument that the government seeks to bring forward tomorrow would create a clash in UK law, because a large volume of EU exit legislation preparing the UK statute book for the moment EU law ceases to apply is due to enter into force automatically on exit day. So in international law, the exit date has already changed, and so this statutory instrument seeks to clarify that in UK law. I hope that's clear to all members.
Thank you. Pete Wishart.
Thank you very much, Mr Speaker. We all look forward to the Leader of the House's motion tomorrow, so this can be properly discussed. But I think we're all particularly looking forward to a little bit of parliamentary innovation tomorrow. And I'm looking around for Prime Minister Letwin, and he must still be with the Queen discussing the Parliament Party legislative programme, which we will obviously get an opportunity to consider and debate tomorrow. And I get the sense, Mr Speaker, that Parliament's about to take control of this process with all the enthusiasm of the First Lieutenant of the Titanic taking over from Captain Edward John Smith. But can Leader of the House confirm today that whatever the outcomes which are agreed tomorrow in this great piece of parliamentary novelty, that if there is a majority, the government will observe and respect it? Now, this is the thing that this House really needs to hear from the First Minister, because we are sick and tired of voting repeatedly on motions which are passed for this government to casually and contemptuously ignore them. So will they cooperate fully in ensuring that we do get to some sort of solution with this House, and will they respect and observe it?
Well, I would reject what the Honourable Gentleman says about the government ignoring this House. It is, of course, as a result of the motion that was passed by this House on March the 14th that we do have an extension to Article 50. And as he knows well, as Leader of the Commons, I take very seriously my role to be Parliament's voice in government. But what I can say to him in terms of the options that will be brought forward tomorrow, the first point is, at this stage, we don't know which options will be debated and voted on, let alone which will pass. And to use his analogy, my right honourable friend, the new Prime Minister for West Dorset, hasn't yet indicated that manifesto, nor indeed has the right honourable member for Leeds Central indicated his manifesto. So I think we need to wait for that advice. I do jest in case any honourable member is determined to take offence at my joke there, Mr Speaker, just for the clarity in this chamber. The second point, of course, is that any options that are passed by this House must be negotiable. So they have to be deliverable in negotiations with the EU, and they would also have to take account of how long those negotiations would take. And then finally, as my right honourable friend the Prime Minister pointed out in the discussion yesterday, and as the Shadow Brexit Secretary was also clear in the House, it would not be possible for different parties to accept proposals that their party manifestos rejected at the last general election. Well, the Shadow Brexit Secretary was clear in the House yesterday that Labour would reject certain potential outcomes as inconsistent with the Labour manifesto. So the Right Honourable Lady shouts rubbish, but she needs to talk to her front bench. It's absolutely vital that this House delivers outcomes that are negotiable and are feasible and in line with the will of the manifestos and the referendum that we all stood on.
Sir Desmond Swain.
If the measure was defeated or she stayed her hand, then the European Communities Act 1972 would cease to apply on Friday evening and would be free, wouldn't we?
Well, my right honourable friend is correct to say that a commencement order is required under Section 25(4) of the EU Withdrawal Act in order to give effect to the repeal, and the timing of that commencement order will depend on the date we leave the EU. So we need to commence the repeal of the ECA on the date of our departure, which is either the 12th of April as things stand if the deal is not approved, or the 22nd of May if the deal is approved.
Angela Eagle.
Thank you, Mr. Speaker, and can I join the Leader of the House in welcoming her resistance to what I must now call the anarcho-extremists on her own side, who want to mess around by voting against the motion she has brought today to put UK law in line with the international treaty agreements that the Prime Minister has made. But would she clarify something that she said in her statement? Yesterday the Prime Minister said she was no longer going to bring the deal back for a third meaningful vote 3, but the Leader of the House has just said that that might happen this week. Can she clarify which is true? Well said.
The Prime Minister has said that she will continue to seek further support for the withdrawal agreement and political declaration, and should she succeed in that, then we will seek to bring back the meaningful vote for this House to consider. And to be clear again, it is only if this House approves the withdrawal agreement before the 11 p.m. on the 29th of March that then there is an extension to May the 22nd.
Dr. Julian Lewis.
If this House does not approve the withdrawal agreement, indeed it might be that the withdrawal agreement isn't able to be brought back before this House anyway, and if the Prime Minister therefore decides that exiting on WTO terms is preferable to no Brexit, is there anything that this House can actually do to prevent the Prime Minister ensuring that we exit on WTO terms? I think the answer to that question is no, isn't it?
Well, I think that my honourable friend is posing an unanswerable question because, of course, the ingenuity of the House knows no bounds. And I think that what the House has been clear on is that it does not want a no-deal Brexit or a Brexit on WTO terms, which is a desire that I share. But as we have always been clear, the way to avoid a no-deal Brexit is by voting for the deal. And if I may, Mr. Speaker, I will quote from the EU Council conclusions directly. The European Council reiterates that there can be no opening of the withdrawal agreement that was agreed between the Union and the United Kingdom in November 2018. Any unilateral commitment, statement or other act should be compatible with the letter and the spirit of the withdrawal agreement. So all of the terms under which the UK leaves the EU are subject to the agreement by this House of the withdrawal agreement.
I think it's potty to announce today that we're going to have the SI tomorrow evening at the fag end of the business. Absolutely ludicrous, when we could perfectly easily do it on Thursday. But can I just ask the Leader of the House whether we'll be sitting on Friday, because I have a particular interest, namely the fact that it's Brain Tumour Research Day, and they're encouraging everybody around the country to wear a hat to work on that day. And as you will know, Mr. Speaker, Erskine May is silent on page 451 now as to whether we can wear a hat in the chamber, though I think we are expected to speak uncovered. So wouldn't it be a good idea if the Leader of the House could announce now that if we are sitting on Friday that we're going to do that on Friday, or if not, we can all wear hats on Thursday?
Yeah. Excellent. Well, I can tell the honourable gentleman that I once wore a hat because I wanted to take my hat off to the Right Honourable Baroness Jowell, who is sadly no longer with us, over her brilliance in establishing Sure Start. So I can tell you, Mr. Speaker, that you tolerated my wearing of a hat in honour of what I felt was a very good cause. But the honourable gentleman asks a very specific question, and as he will be aware, at the moment there are no plans to sit on Friday, and if there were plans to do that, then that would require the passing of a motion to that effect, which this House itself would have to agree.
Vicky Ford.
Thank you, Mr. Speaker. Can my right honourable friend confirm that to get the longer extension, requires the passing of the withdrawal agreement, not the withdrawal agreement plus the political declaration, and that the political declaration itself provides for a wide spectrum of different potential outcomes to the long-term relationship between the UK and the EU.
Yes, my honourable friend is right that the EU Council decision requires that this House has agreed the withdrawal agreement, or has introduced the withdrawal agreement in order to get the long extension ready for the legislation. And I would just encourage all honourable members to consider that a lot of the proposals being put forward for tomorrow would themselves require a withdrawal agreement to be approved in order for them to be taken forward. So we need to be clear that what we're talking about in the indicative votes tomorrow is potentially replacements for the future arrangements as opposed to for the withdrawal agreement. So I do urge honourable members again to consider the Prime Minister's deal and to accept the reality, which is that the European Council requires us to look positively at the withdrawal agreement.
Mr. Speaker, the Leader of the House knows, and I welcome the fact that I'm semi-clear now about what the future progress in the House will be. But would she agree with me that it's most important in this troubled and tumultuous time that we inform our constituents about what we're doing as honestly and openly as possible? And would she stop her colleagues in the Cabinet going on radio and television saying there has been a vote on a people's vote and a second referendum that it hasn't taken place? A minority group in this House moved a motion that was where most of the opposition abstained. There has not been a major vote on a people's opportunity for a new referendum. Will she stop her Cabinet colleagues saying there has been?
Well, what I would say to the honourable gentleman is there very much was a people's vote, and that was in June 2016, and the people decided to leave the European Union.
Craig McKinley.
Thank you, Mr. Speaker. Could the Leader of the House confirm that the very act of the Prime Minister signing that, what is in effect an amendment to the Lisbon Treaty under royal prerogative, actually makes whatever we have to say on the matter of an extension somewhat irrelevant?
Well, what I can say to my honourable friend is that this House voted on the 14th of March for a short extension of Article 50, and at the time the Prime Minister made very clear that if this House were to vote for that short extension, she would seek to negotiate it, but that she could not be certain of what the EU would offer in return. So my honourable friend is right. The Prime Minister agreed a short extension that wasn't necessarily exactly every individual's definition of what that should be, but she agreed it on behalf of the United Kingdom, and as such, in international law, the date of our exit from the EU has now changed irreversibly to April the 12th or to May the 22nd if we have agreed to progress with the withdrawal agreement.
Neil Gray.
Speaker, is it the Government's intention to table its own business motion for the Speaker to deliberate on regarding tomorrow's business?
Good question.
As I set out in the business statement just now, the first business tomorrow will reflect the decision taken by the House yesterday, and at the conclusion of that business, the Government will bring forward the draft European Union Withdrawal Act 2018 Amendment Regulations 2019.
Philip Holloway.
Given that the Leader of the House has said that we're not sitting on Friday, and given that House business takes priority tomorrow, does the Leader of the House expect to make a business statement at the end of House business tomorrow, announcing that the meaningful vote will take place on Thursday?
Well, I can't give my honourable friend absolute certainty on any issues of future business right now, because, as I've set out, we are continuing to seek support for the Prime Minister's deal, and that is absolutely the focus for government. And should we feel that there is sufficient support for that deal, then we would seek to bring that vote back, because what that would mean is that by the end of this week we would be in a position to be having an orderly departure from the European Union with a close economic and security partnership to go with it.
Clive Efford.
Mr. Speaker, I'm sorry if I missed it, but could the Leader of the House clarify the business tomorrow? Is there protected time for this SI? It seems strange to cram it in tomorrow given the decisions that the House has made about debates tomorrow. So can she clarify how much business there will be? Will we have protected time for it? And will the government be putting its own business motion to deal with the indicative votes tomorrow?
So I think what honourable members will realise is that the vote yesterday was that the government wouldn't be responsible for tomorrow's business, and the government is seeking to engage with those who do have control of tomorrow's business in a productive and constructive way to ensure that this very important statutory instrument that will provide certainty to businesses and citizens, not about our departure date but about the legal certainty in between the 29th of March and the 12th of April in the first instance. And so the government is working closely with those honourable and right honourable members who are controlling the business tomorrow to seek the agreement that government business will be able to carry on after the moment of interruption. And as is normal with statutory instruments, I would expect that to be for a 90-minute discussion followed by a vote at the end, but that's not in my hands.
Alison Hewlett.
Okay, Mr Speaker, the Leader of the House had a real lack of clarity as to whether meaningful vote 3 would come back this week, next week or perhaps even the week after. In the question sessions for the week beginning the 8th of April and the week beginning the 15th of April are now available for tabling on the Parliament Member Hub, will she confirm what we all know to be self-evident, that recess is cancelled?
Yeah.
I think the honourable lady's question is with regards to recess. So, as she will know, I have announced the dates for Easter recess, but, as is always the case, recess dates are announced subject to the progress of business. We will need time in the House either to find a way forward or to pass the withdrawal agreement bill, and I think the country will rightly expect Parliament to be working flat out in either scenario. So further announcements on future recess dates will be announced in due course in the usual way.
Mr Angus Brendan McNeill.
Thank you very much, Mr Speaker. In answering my honourable friend from Perth and North Perthshire, the Leader of the House said anything the House comes forward with must be negotiable and deliverable before the government is supported. Tomorrow, with cross-party colleagues, I'll be bringing forward an amendment on the revocation of Article 50, so we don't leave with no deal, avoiding a no-deal Brexit. And given that revocation has the virtue of requiring no negotiation and is deliverable, could she confirm, therefore, that on an indicative vote tomorrow, were that to be passed, that she would indeed respect that vote?
What I can say to the honourable gentleman is we'll wait to see what the indicative votes are on tomorrow before deciding how to respond to them.
Alex Cunningham.
Mr Speaker, the Leader's already talked about Easter recess, and one of the dates that she's mentioned this morning is, in fact, during that Easter recess period. The table office are already populating that fortnight for questions. When is the government going to come clean and tell us that Easter recess is cancelled?
Well, I refer the honourable gentleman to the response I just gave. Easter recess, it has been announced, but it will be subject to the progress of business. And, of course, what we're hoping is that we will have a clear way forward within the next few days. And I will make a further statement on recesses as soon as I can.
Gavin Newlands.
Mr Speaker, following the question from the honourable member for Leadsom just a minute ago, could the Leader perhaps clarify whether, and I'm sorry if I missed this, whether the 4 SIs that are currently on the order paper tomorrow for exiting the European Union on food, protection of trading interests, animals and a constitutional law SI, where they're going to remain as Chamber of Business. I ask, Mr Speaker, because there's a rather excellent adjournment debate tomorrow night I don't want members to miss out on.
Well, what I can say to the honourable gentleman is, as I said in response to an earlier question, we are in proactive discussions with my right honourable friend, the member for West Dorset, on what government business can take place tomorrow.
Kevin Brennan.
As my friend from the Rhondda has referenced Erskine May's silence on sartorial matters, perhaps the newly elevated right honourable member for West Dorset could appear in the toga that he once wore in debates when he appears before us. But on tomorrow's business, could she clarify what the government's attitude will be if, as expected, tomorrow's indicative votes don't necessarily come up with a solution and more time is required in the future? Will the House have to wrestle that time from the government again, Or rather, given the clear views of the House, will the government be prepared to provide more time in order to settle the matter should it be required?
Well, I don't think there's any issue of wrestling. What we do in this chamber is vote and take decisions. And, of course, the government's position is that the withdrawal agreement and future political declaration are essential to an orderly, proper departure from the European Union. That is the government's position on this. Anything else that is voted on by this House will have to be considered as and when it arises.
B. Jones.
The Conservative manifesto at the last general election was defeated. Is that true?
No.
Thank you. Alan Brown.
Thank you, Mr. Speaker. It feels that the Leader of the House and the Prime Minister still haven't grasped that last night's vote was because Parliament is fed up with the broken record, which is the only way to avoid a no deal is to vote for the withdrawal agreement negotiated by the Prime Minister. And to quote one of the most reasonable and respected ministers that resigned last night, the government continues to play roulette with people's livelihoods. So she's not answered their questions. What will the government do to respect the votes that happen tomorrow, and what measures are put in place to actually contact the EU and plan for legislation to respect the votes?
So the honourable gentleman says it's boring, but it is actually true. The only way to avoid no deal is to vote for a deal. And the second very important truth is that honourable members can put forward other bespoke solutions that they like, but they have to be negotiable. That is the absolutely incontrovertible fact, is we cannot in this House just decide. It requires the EU to negotiate the other side of that transaction. So what the government will be doing is looking very carefully at what the indicative votes show tomorrow and then making its response accordingly.
Point of order. Crispin Blunt.
I had hoped to raise this point of order directly with the Speaker, as it arises from his exchange with the Honourable Lady for Tooting, who raised a point of order about racism in football. And the Speaker gave us a homily on racism in football and its evils from the Chair, which was particularly welcome, coming as it does from a former Secretary of the Immigration Subcommittee of the Monday Club. However, I have raised previously my concerns about the bias of the Speaker, and I would be grateful if you could convey to him that the fewer views he expresses, either from the Chair or as the Speaker, the less we will have anxiety about his bias.
We now need to press on with the business in hand. We now come to the presentation of Bill Caroline Lucas.
Decarbonisation and Economic Strategy Bill.
Second reading what day?
5th of April.
5th of April. Thanks. We now come to the 10-minute rule bill. Andrew Griffiths.
I beg to move that leave be given to bring in a bill to require the Lord Chancellor to report on the use of, by courts of compensation orders for child sexual abuse offences and for connected purposes. Mr. Speaker, Mr. Deputy Speaker, people come to this House for many reasons: to deliver Brexit, to fight racism, to champion social justice, or to reform Parliament. But I'm sure that all of us in this House, from all parties, all sides of the chamber, come here to help the victims, the vulnerable, those who have the least voice. And there can be fewer in society in need of our help than the victims of crime, and in particular, victims of child sexual abuse. We have discussed in this House regularly the abuse that has occurred in our country. It has occupied much of our time here in this chamber. We have discussed the abuse that took place, the horrendous abuse that took place in the 1970s. We have discussed the abuse in the Catholic Church and in the Church of England. More recently, we have spent a great deal of time in this House talking about the horrific and widespread abuse in towns up and down the country, such as Rotherham and Bradford. The suffering that those children have had to go through is indescribable and unimaginable. And it is only right that this place spends our time doing all we can to reduce the possibility of such things happening again. Nobody can take away from those victims the pain that their abuse has caused, the trauma and the suffering that they have endured, not just as a child when the abuse was happening, but all too often in later life. That trauma comes back and bubbles to the surface. We all want to do our very best in this place for those survivors. And as someone, Mr. Deputy Speaker, who myself was a victim of child sexual abuse, I know how difficult and traumatic it is to discuss these issues. I had kept my secret hidden for some 40 years. I locked it away and chained it down and hoped it would never surface. I convinced myself that if I didn't give it words, I denied it a reality. That was my view, and how wrong I was. Talking about what happened to me, explaining to other people, was the best thing that I could possibly have done. And I hope that other people who maybe see this debate or read my testimony will themselves think about coming forward and speaking out about their abuse and the trauma that they have suffered. Mr. Speaker, to talk about these things takes courage. And if it took me, as an individual, to be sat in a psychiatric ward talking to a psychiatrist to be able to talk about my trauma, how much more difficult must it be for those victims who find themselves in the courtroom, who find themselves in that intimidating and foreboding place, who have to suffer the cross-examination by a skilled and forensic barrister, who have to, across the courtroom, all too often face the perpetrator, face the person that caused them so much pain and so much anguish over their lifetime. And yet they do it. And the prospect of having to retell and relive the story of their abuse in the courtroom. This was actually consolidated in the Criminal Courts and Sentencing Act in 2000. The Sentencing Council themselves say the court must order compensation whenever possible and should not have regard to other sources such as the civil litigation or the criminal injuries compensation scheme. So if everyone agrees that the survivors should get compensation as of right, and judges have the power to be able to award that compensation straight away at the time of sentencing, then of course CCOs in child sexual abuse cases should be used regularly and with good effect. Surely that's a given. Sadly, the answer is a resounding no. In 2017, the last year for which figures were available, some 6,861 convictions took place. 6,861 people found guilty and sentenced for committing a child sexual abuse crime. Yet of those 6,861 where a CCO could have been used, how many received one? How many would the House suggest? 50%, 25%, 10% even. The shocking reality is of the 6,861 cases, just 26 received compensation from a CCO. That is just 0.4%. And Mr. Deputy Speaker, that is a